Well, in a car wreck, the first part of any case is the liability aspect, which is we have to be able to establish that the person or the defendant caused and is responsible for the subsequent injuries and damages that you've sustained. And so in a car wreck, generally the liability part is much easier. Sometimes it gets very complicated depending on how many cars were involved. There could be a lot of different factors that could make and complicate the issue of liability. But initially, on a straightforward rear-end accident, the guy who hit you for not slowing down in time is the responsible party, and that establishes liability. But for example, if you have a slip and fall case and you slipped and you hurt yourself, the question of liability is always a big issue because we have to be able to establish one of two things. One, that the person who owns the facility or the location where you fell caused the dangerous substance to be on the floor, which resulted in you falling, or that they had what they call constructive notice of it, which is that the item, let's say it's ice cream, had been spilt on their floor for 30 minutes, and they had 10 employees walk by and just not clean it up. That would be a way to establish liability because they should have cleaned it up. The standard is that they knew or should have known that there was a dangerous substance on the ground. And so that's how we have to deal with liability.